CT 173498, Goldie Counsel versus Alex Counsel. We'll have both parties raise their right hands to be sworn, please.
You and each of you do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
You tell them?
Yes.
Thank you.
All right, Mr. Stoffel, Mr. Carmen, your appearances for the record, please.
Jason Stoffel, bar number 8898, on behalf of applicant, present in court today.
And Michael Carmen, bar number 7639, Judge.
All right, everybody can be seated and comfortable. We're scheduled today on the adverse parties.
Motion to dissolve.
Motion to dissolve. There's also before the court a motion filed by the applicant requesting this court to issue an order to show cause why the adverse parties should not be held in contempt of court. That was more of a setting for convenience because we already had the date set than it was set in the ordinary course.
Yeah, and I was going to say, on the order to show cause, because of the timing of everything, I know that Mr. Stoffel's office tried to give me a whole bunch of exhibits by email that did not come through this week. He didn't know about it because I was in Mexico at the time and out of touch. So, yeah, as far as the order to show cause goes, I hope Your Honor can treat those as two separate issues and that we can address the order to show cause at a different time. I can tell you my client adamantly denies the order to show cause allegations. Not only does he deny it, but the information that she's provided to this court shows that he didn't do it. This supposed hacking of a Facebook account, first of all, which was their joint account, but to the extent she's alleged that he somehow hacked his own account, it looked like someone accessed it from Riverside, California, and tried to change the email to Suze something, S-U-Z-E. This is not my client's email. I don't know why she thinks that he did anything to that account.
Well, the fortunate part about this is we still have the September 7th date available.
Okay.
And at the conclusion of this hearing, we'll make a determination as to whether we'll use that date, vacate that date, keep it for some other purpose.
Understood.
But yeah, it wouldn't be appropriate if there are still exhibits that are forthcoming to be presented to the adverse party that we really make a determination today as to whether we're going to issue an order to show cause and have an evidentiary hearing at that point. We can defer that for a later date after we get through this portion. So what we have is adverse parties motion requesting the dissolution of the order of protection that was issued on August 2nd, and we have that date, as I mentioned, September 7th, which is designed to entertain the request to extend the order of protection. So I guess, Mr. Carmen,
in regard to the motion to dissolve, Judge, we briefed this in as much depth as we could under the time constraints that we had. But how this has all gone along should be very troubling to the court. I don't know. The one thing I don't know if you've had a chance is to listen to the audio exhibits that we presented to the court.
I didn't because I felt it important for Mr. Stoffel to be able to, one, if he had an opportunity to listen to them before I did, object if there was anything questionable. So I have not heard the audio. I saw that there was a supplement
Correct.
with it attached, but I didn't listen.
And as an offer of proof, well, first of all, they were given to Mr. Stoffel, and I confirm that he did receive them, so there is no notice issue. But the audio recordings are deeply disturbing, Judge. They're attacks upon him, threats upon him, veiled threats, overt threats, all in front of the children for days leading up to the issuance of this, leading up to this incident that occurred at the house. They've been in front of this TPO court before, after he was attacked by his son at her insistence in January. This is a repeat of that. She antagonizes him, and it's all on audio tape, gets this child, Gavin, the oldest child, worked up to the point where he lashes out against Dad. He lashed out against Dad this time around. Dad restrained him, did absolutely nothing inappropriate. When you're being beaten by your child, when you're being hit on the head by your child with a picture, the appropriate thing for a parent to do is to restrain them and de-escalate the situation, which he did. He acted completely appropriate in these circumstances. She, on the other hand, did not. She has antagonized him, and even though you haven't heard the audio tapes, you've seen the text messages. For the time period between this incident occurring and the time that she sought this TPO, it's important for Your Honor to scrutinize her conduct. Because her conduct is this. This person who's coming before this court saying she's afraid of him, that he's somehow a danger to her, she antagonized him and antagonized him and antagonized him in front of friends, in front of family members, in front of the children, and hid the children from him. She immediately puts the children on a plane and flies them out of state. She goes to school, unenrolls them from their school without dad's consent, re-enrolls them in a new school without dad's consent. She decides that she's not going to allow the youngest son, Gage, to play football anymore. She engages in unilateral decision-making in violation of the joint legal custody orders, which, as far as I can tell, remain unaffected by the issuance of this TPO, but for the fact there are some limitations on communication.
When was the legal custody determination an order of the court?
He has joint legal custody by operation of law, Your Honor.
Right, not by
order. My point
not
is,
by order.
She has used this TPO and she has convinced school personnel that she now has legal custody rights and has unilaterally. She actually unenrolled their son, their oldest son, from Bishop Gorman and re-enrolled him in a different school. She puts him on a plane, takes him to Seattle over his objection without his consent. The youngest child, she's threatening to pull out of football. She's threatening to alter his school enrollment. I reach out to Mr. Stoffel and say, hey, let's put the brakes on this. My initial call to Mr. Stoffel said, let me talk to her, I'll try to get her on board. He can't. The reason the motion to dissolve was filed when it was is because when I immediately reached out to Mr. Stoffel, I expected some cooperation as far as parenting decisions, as far as long-term decisions affecting the welfare of the children, and Mr. Stoffel, unfortunately, was unable to get the cooperation of his client who's taken the kids, who's taken the dogs, who, while she says she's afraid, sends him harassing and threatening text messages through their friends, through this. She starts this text feed with all of their mutual friends, through church, through their children's activities, and harasses him, antagonizes him, calls him terrible names, accuses him of doing things he did not do, and uses it to try to coax him into contacting her. This person who's desperately afraid is sending him text messages saying, if you do not respond, then I'm going to sell Star Wars figures, then I'm going to do this, then I'm going to do that. This is a person who has wielded this TPO, Your Honor, as a weapon. And if we're going to put her under oath and we're going to ask her questions today, I want this court to ask her whether she filed this after meeting with her attorney, whether she filed this after filing the D case as a method of gaining advantage in the D case, because I don't know how this can be interpreted any other way. They file a D case, they don't serve it, she goes and gets a TPO through an application that really doesn't make any sense. She talks about sexual tension in the household and this ridiculous allegation against him, but the voicemails, I don't know if you want me to play them, if you could take some time to listen to them, Your Honor. But they tell such a different story. They tell a story of a woman who's possibly drunk and antagonistic, openly antagonizing him, openly attacking him in front of the kids. I don't know how this person can come to this court and seek the protection of a TPO when my client has been victimized. He's been victimized not only in the household with her getting the kids riled up against him, but also in those text messages, Judge. What she's doing, reaching out to his friends and telling them he won't give her shoes, and if he doesn't come to her, if he doesn't allow her to pick up shoes, he's going to be sorry. All these threats. This is improper behavior, and if one of those text messages is really, it would be funny if this wasn't so serious, Judge. But she demands that he allow her into the house to pick up her shoes. This is after she took the kids, took the dogs, took everything. He makes some arrangements, first time around, second time around, this is all before the TPO too. I don't even think he violated the TPO. But after the second time around, I believe it was after he hired counsel, we told him to cut off all communication. We'll go through Mr. Stoffel. Of course, I told Mr. Stoffel if she needs her belongings, just give me a list of what she needs and we'll make arrangements. This shouldn't be an argument. This shouldn't be a fight.
I understood that she had an opportunity and got most of the...
She got some. She's still complaining about not getting them all.
I'm familiar with the shoes.
Yeah, and look, that text message just says a lot, Judge. While she's antagonizing him about these shoes, and her friends are mocking him and saying, oh, her new date is going to buy her nicer shoes or whatever it was, I'm paraphrasing. While this is all going on, she then, one of those text messages, says, oh, now my shoes are hot. The reason she says that is because she turned off the utilities at the house while this is going on.
All right, here's some, I need some timing issues answered, because this is what I know, and I'm familiar. I've read most of the materials,
appreciate that,
even going back to the prior case from January. Where I was puzzled was there's an indication that he hadn't had contact with the children since mid-June.
It was July, mid-July.
It was July 19th. There was a typo.
Okay.
My apologies.
All
It
right.
was my
No,
typo.
it's okay.
But-
That helps clarify it,
Yeah.
because I was curious. From April is when the kind of the reunification became effectuated. There was an order in the middle of March dismissing a D case and dissolving a prior order of protection.
Correct.
I saw that there was an order of protection that was extended for an entire year due to an arrest back in January. What I was curious about, and I'm familiar with the application, I'm the one that issued the order of protection, and I will tell you the basis for my issuing the order of protection was that there were allegations, sworn testimony, that a 15-year-old's face was planted into the wall, breaking his glasses. It wasn't so much about the sexual tension. It probably wasn't even so much about the hacking of the email or the tracking of the cell phone, although I'm interested in these issues because those, under our definition, can fit what constitutes a threat or an act of domestic violence. But and then there was this forced relocation again. I understood that applicant had secured a new apartment and then felt so scared and intimidated that 2 days after securing an apartment, she left that apartment and moved again. So that was a trigger to the court that we needed to put something in place until we could
Right,
get
and
here
you
for
hadn't
this
heard his side
particular
of the
hearing.
I don't want my motion to dissolve to be viewed as a criticism of this court. I understand you're dealing with a
I'm not.
one-sided
You
application.
have every right to come in on a very short order. We have a provision in our statutes that allow for you to get in as soon as reasonably possible, and that's what we did. We did it so much so that you couldn't come the day we assigned it, and we moved it
Too efficient.
back a day. We were too quick on our order shortening time, but. And then on July 21st, I understand there was a police escort to the old home to be able to get
That's
the
correct.
belongings. And again, we're not going to make light of this. What we do here, we take very seriously. But if shoes were of such a priority, we would have grabbed them at the police escort, I would think, and picked them up, and they wouldn't be in it. And most of the time, I'll tell you, just to put a kibosh on the shoe issue, is most victims that sit where you're sitting run out of a home with only their bare necessities and their flip-flops, and they're not really concerned about shoes going forward when they're truly victims of domestic violence. But that doesn't excuse the rest of some of what's going on. Mr. Stoffel, I want to give you a chance to respond. But I had 716 was the unwanted advance or the sexual tension, as it's been alluded to. We had July 17th, the tracking of the applicant's phone calls. We had 718, hacking email, where she had secured a residence and he somehow acquired a copy of her lease. She was trying to do this confidentially, and he must have accessed, at least the allegation is, accessed her electronic media to be able to see the lease. On 7/19, July 19th, there's an allegation or testimony regarding the adverse party going to the apartment and peering through the window of one of the new apartments. I don't know if it was the first one. It must have been the first one, because the second one was 2 days after that. And then we had the smashing of the 15-year-old's face into the wall and the breaking of the glasses. That was what the application contained. Okay, and so the children leaving the state, when, or being sent out of state, I'm not aware of that.
You have to ask her about it. She sent the children to, I believe, her sister's house or someone's house up in Seattle.
When?
Sometime after this incident and today. We don't know. We don't know if the kids are back yet. And here's part of the frustration, Judge, and it needs to be addressed, is I'm reaching out to her counsel, trying to get basic information. Is the child going to be back and attending his school on Monday? First, the answer is, well, of course the child's going to be attending school. The second answer is, no, she's decided he's not going to Bishop Gorman anymore, and I think he'll be back Wednesday. We still don't really know where these kids are and what's been going on.
Okay, so what went wrong between April, when we started the reunification process, the first thing mentioned is that July 16th sexual tension or unwanted advance. Was there something between April and July that sent this in an opposite direction?
Between April and July, the parties were living the life. They were vacationing together. They were attending children's activities together. They were attending their son's football tournament out in California. Everything was fine until my client reports until around the beginning of June. Between June and July, things started to get a little weird around the house. And that's where these recordings are important, Judge. For her to sit here and say that he's a threat and that he's a danger, those recordings will alleviate any concerns that you might have.
All right, after we hear from Mr. Stoffel, we'll make a determination whether we need to hear those or not. Here's why I was thrown off. I understood that there was this June date, because it was a typo, I get it, but I thought there was a gap period of time between June and July, and I was thinking maybe the parties were separated at that. Okay, so up until July 16th, the parties were residing together,
looking to get a house together. Honestly, there were difficulties and tensions, and you'll listen to those recordings about what the cause of those problems were. But the day that this all went down, they were driving around town as a family. They stopped at a convenience store. He walked in to get a Red Bull, came out and she had abandoned him, went back and started cleaning out the house. This is a professional hit, Judge. I don't know.
All right.
We're here, and here's the bottom line. I just want to make sure that you understand where we're coming from. We're fine with any mutual behavior order. We're fine with anything to put in place instead of a TPO. He just wants to start seeing his children again. He wants to have some input into their lives again. He would love for them.
The complaint asks for sole legal, sole physical.
She thinks she has sole legal and sole physical, and unfortunately the schools have agreed with her so far and have said that she has decision maker. The child is unenrolled from Gorman. That ship apparently has sailed now. They had a $3,000 grant that the child had to help with tuition. It's gone. The ship has sailed. She did that. She masterminded that. I hope she's proud of herself. The youngest child, Gage, should go to the International Christian Academy where he was supposed to go. He was scheduled to take a placement test there. We don't know whether she sent him in for his placement test. We don't know what her intentions are for schooling for the younger child. And the younger child is supposed to be in football. He is a football star who plays with the Bishop Gorman team that Dad coaches, and she's refusing to let him participate in his activities.
The eldest child.
The younger child is the one who's the football star.
With Bishop Gorman.
The oldest child, like I said, he should have been going to Gorman. What she's done is absolutely inappropriate. I hope this court isn't going to tolerate what she's done.
All right, so if we grant your motion, and certainly we haven't made any determination yet, but if we grant it, we are left with two parties who don't have an existing timeshare arrangement, who don't have an existing order, and it's not going to happen until we get into the D case, and there's no motion even pending for that to be resolved. Can we leave these two up to their own devices? Because I won't have jurisdiction to make any issue of or make any orders relative to custody and visitation without an order of protection in place.
I understand that, and I'm fine with you recommending the dissolution of the TPO to the court and putting temporary orders in place until we're in front of Judge Moss. Listen, I agree with you 100%. If there's a vacuum, I don't know if it could possibly be worse than what's going on right now.
I mean, I trust you and Mr. Stoffel to gain some control and reins over this and put something in place if it's appropriate, but I don't know that these two are going to allow.
I'm telling you,
counsel.
yeah, and then that's Mr. Stoffel and I work very well together. If he had any control over his client whatsoever, we would not be here today, Judge. This is a hearing that should not have to go forward under any circumstances.
Let's not speculate anymore. Then, Mr. Stoffel, I need to hear from you.
Well, I think the first thing we got to figure out is what involvement with this department do we want to do at this point forward? Do we want to just say do whatever today and then kick it all to Judge Moss and Department I? I'm not sure what we want to do.
And that would be potentially the protocol if there was a pending D case motion or hearing date. I don't know, ordinary course in Department I can drag us out for some time. As you saw, there was a motion that should have been directed to this court that got filed in the D case, and ordinary course put us in the middle of October. So had this been directed to Judge Moss pursuant to however it got scheduled, we wouldn't have been before Judge Moss on this motion to dissolve until October. So What we have to decide is whether there's an impending risk or threat of domestic violence going forward is essentially the burden of today's hearing. I don't want to backdoor our way into trying to craft a custody order, because that's not what this court is. That's not our job.
Right.
Our job is to determine whether there's a need for an order of protection.
Right.
The only problem, Judge, with your analysis is that the order has given her physical custody, and with that order, all third parties, the schools and everyone involved, is treating that TPO as an order granting her
I
legal
understand,
custody.
and I'm discouraged to learn that a place at Bishop Gorman has been lost as a result of this. That was not the intention or the spirit of our order. The spirit of our order, and it extended not just to custody, it was issued on behalf of the 2 minor children in light of the testimony. I'm glad we're in on short order. I don't know whether we can salvage what's happened with the schools or whether we need to, but let's, again, we're getting ahead of ourselves. Mr. Stoffel, make your presentation, and then we'll try to put something together if we need to.
I think the biggest thing with the school thing, and this is what I've been trying to convey, is there's just not money for Bishop Gorman. That was the main thing in this case. There was $68,000 that was available for the parties when they sold a residence about a year or so ago. That money has been burned through and gone. Obviously, Bishop Gorman requires money. It's over $1,200 a month to do, enroll there. And this was something that parties have had their discussions. I know that from what she's telling me, Gavin hated that school. But beyond that, it was a money thing, pure finances. If you do not pay for school, you do not get in. His grades tanked. He was always, 3.7, something like that. When he went to Gorman, he was around 2.7, 2.8. She's given me documents on that. She showed me some things, certainly. So that's the number one reason with the whole Gorman thing is not there.
I want to know why we need an order of protection.
Mainly because
there's no way I'm going to figure out what school and
understand
the finances and all that. That's for Judge Moss to work through, or the
understand.
parties if there's not an order of protection in place.
I understand. So just the last thing that she did is enrolled Gavin into the Las Vegas Academy of the Arts, and that's a school that works. It'll be effective. If they want to determine something else, they'll have their day in court at a later time, but there just wasn't money for Bishop Gorman. Now, as far as order of protection, what she's telling me is the recordings that they submitted, which I believe is their supplemental Exhibit C, were recordings from 2015. 2016, 2015. It predated the first TPO. Other things, other text messages, there's pictures of, I think it was a candy bar of World's Greatest Dad and all these things. These are all things that are a couple years old. You look at the children in these pictures, they're a couple years old. It was happier times in 2014 and 2015. So what he's trying to do is saying, we're a great family, mom's crazy, here's some video, here's some audio. And this is something that when you have it where, one party's being recorded, of course, she is reacting in a way that she deems appropriate or deems that it's kind of historical what they've been doing. He knows he's recording, so he's on his best behavior. So on its face, these recordings from 2015 might appear that, Dad's the angel, Mom's the devil. That's kind of how it comes across.
Are we able to determine from the recordings
Yeah.
the dates of the recordings?
We could have a forensic expert
This
go
is
in
why
there.
I don't listen to them.
Yeah, there's a unique signature made with each electronic file that's saved on a phone that'll tell you the date. I can tell you the dates were verified by my client. There were some that predated the other TPO that were examples of the conduct that led up to the other TPO too, but they were clearly dated as such.
Well, as far as today, what we're here is what protection order is needed. What we have is undisputed facts that there was a scuffle between Dad and Gavin. A scuffle to the extent that he got his glasses broken, he got his face cut. Mom called Metro. Metro came out, they looked, saw Gavin, saw Dad, and just basically said, you're fighting on community property, a dog. Basically, grow up, see ya, and that was out of there. And they were out of there. So there were no arrests that were made on that thing. So she did call the police. Then when she left a couple days, or when she left thereafter, got another place, what creeped her out, and if I could just be candid on this one, Goldie, is she had some coffee mugs and things set up, and she comes home one day, and magically there's a coffee mug that he has that was placed right next to her that scared the living hell out of her. And so she said, now he's stalking me. Now he knows where I'm at. Now I see that my Facebook settings have changed. Now I see emails hacked. He works for a spy company, Your Honor. Sting is the name of the company he works for. So he has special knowledge of how to do things, how to hack certain things.
Where was the coffee mug located?
at her residence after the scuffle on July 19th. It was next to her coffee mug. It wouldn't have been there. No burglar is going to come
At
in.
a new residence.
At a new residence.
Okay,
So
so
then you have the stalking thing. So this has certainly led up to, I need an order of protection. So she didn't even meet me until I think the early August, end of July. So this has all happened before I was even involved. So when she moved out of the July 19th marital apartment residence to another place, she didn't want to be found by him at that moment in time. How did he find out where she was? Hacked through emails, probably saw a lease, saw something, so that she had to get another residence. She said, okay, enough's enough. Then, after he was served with the TPO, he got into the blocking the unknown callers and called her and called her and called her. They're going to say, how do you prove it's him? Okay. Good question. How do you prove it is? Okay. You kind of add 2 and 2, and you have what you have. Then he went so far as to find a number from Indiana that you can get and use Google and manipulate as you see fit. It was an area code from Indiana that she recognized. So she looks at a number and sees a call from Indiana. And she says, oh, what's going on here? So she picks up and she says, hello. Bet you $2 is on the other phone. It's Alex saying, hello. She hangs up right away. So he's manipulating this. There's emails. There's the Facebook hacking. There's all these things. She does not feel safe. And of course, as far as the children, a couple days after is what I understand of the incident on July 19th, the children were obviously extremely stressed. They want to have at least a summer that they don't have to deal with adult issues. So she did what I would have probably done if I was in her shoes, is to have a couple weeks out of this chaos. As she's trying to figure out her life, getting ready to file for divorce, a family member, I believe her sister up in Seattle, was watching the kids. The kids are back now, so there's no issue. There's never ever a retreat to abscond with the kids or have jurisdiction up in Washington State. There was never anything like that. So she was trying to shield these kids from conflict. So now the kids are back. So when, as far as Mr. Carmen, he wants to know what contact should the kids have, and I said, let me find out. Let me ask, whatever. What I'm hearing from my client is quite disturbing. I'm hearing from Gavin, who's the 15-year-old, basically saying it wants nothing to do with Dad. There's going to be violence if they're together, blah, 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 blah. And, of course, he wants to be heard by someone, whether it's at FMC, whether it's at a private therapist. The problem is there's no money for, like, a Ponzo or a Donna Wilburn to do a private child interview. There's just no money. Neither part. She's not working, and he's got a job. We've got cars that are ready to be repossessed. There's just a lot of drama going on, Your Honor. So, and then as far as the youngest child, who's I guess 10 next month, 9 right now, Gage, he's saying he's going nowhere without his bigger brother because the bigger brother can protect him. And again, this is the same Gavin, the 15-year-old, that got into that scuffle with Dad to the point where gave Dad a black eye. If you go back to the video of the first hearing we had here in February, March, whatever it was, Dad showed up with a black eye that the child gave him a black eye. You have a bad system, a bad circle of violence here, Your Honor, where kids feel empowered, Dad feels empowered to say, I'm the dad, you're going to respect me, and this madness happens, Your Honor. So, and then Gage is telling Mom that if I'm forced to go without you, I'm bringing a knife for my protection. What 9-year-old kid should be saying that type of thing, to say, I want a knife for my protection? We've got kids that are traumatized. So what I want to have somehow, some way, is Dad have some contact with these kids. The question is, how do you go about arranging that contact? Donna's house probably ain't going to cut it because that's a couple more weeks out. That's at least a supervised setting. I said, is there a family member? Is there a relative? Is there, some mutual friend you have? And obviously, you read some of the text messages. She was, of course, venting to some of her friends, and messages get shuffled around. None of their friends or mutual friends want to be involved in this process. So I don't know how we get it. I hate to say, have it at a Chuck E. Cheese and best of luck to you, but what do you do? What do you do? And there really was no way to have contact that I guess Mom or at least the kids were comfortable with. And again, the kids weren't even around until just recently. They were up in Seattle outside of this situation.
How long were they in Seattle?
About 2 weeks, right? 2 weeks. So they were there.
From when to when?
I don't
Do you remember the date? It was like July 22 or so to about after July 19th.
You had relocated?
Right. Yes. Right after I.
The coffee mug incident.
Right after I moved into the new apartment, the second apartment.
What prompted you to seek a new residence, and when did you start that search?
I started the search because I knew he was. What led up to July the 19th was on the 18th. I rented the apartment, and
that's what I'm getting at. He believed that there was this reconciliation, that you were living, I think Mr. Carmen used the highlight, you were traveling together.
We traveled together, but we were, if you look at my phone, you'll see that all the way back until May, I just emailed part of the extension for the TPO. I emailed over 700 screenshots over to my attorney this week. All the way back in May, I was asking Alex to stop texting me obsessively. I couldn't leave the house. I couldn't go anywhere that he didn't call me 10 times. I asked him all the way back in May, stop texting me like this. We're co-parenting and coexisting. And if you look at the hearing on when I dissolved it, it clearly states that the parties are working towards co-parenting and counseling with the children. That's what I agreed to, not complete reconciliation
But why
at
couldn't
all.
you, if that were the case, you could do that and
Live separately.
be divorced or live separately.
Right. Well, we couldn't because we were both unemployed. And so we agreed to be roommates in that apartment. And he clearly stated that I could put my belongings in the garage, and that if I felt uncomfortable and I wanted to move again, that I could clearly take my belongings and I would be allowed to go. He knew prior to the 19th I was leaving because I was packing my things up to go. All of our friends knew that I did not want to be with him any longer. I could dissect this motion down to, there are 14 incorrect statements in his motion, clearly. All the way back to he didn't have a clue that I wanted a divorce originally back in January, which is a false statement because I asked for a divorce back in September of 2015. But back to the 19th, I rented the apartment on the 18th. On the 19th, he came home late. He had just started a new job, so it was about 2 weeks into it. And he came home late. I had gone and gotten stuff to grill out. And we grilled out, and I tried to talk to him that, I wanted to leave and I wanted to move. I had a friend that came over that actually helped move me out of my previous move. She came over and she was talking. He started getting hostile because I had packed up and moved a lamp out of Gage's room. And while she was there, he's like, "Where's the lamp out of Gage's room?" And I said, "Well, remember, I bought that after we had filed for divorce. I'm going to take that with me." And I had asked my friend, "Well, you probably should leave." It escalated to the point that he was following me around in the apartment, going on and on. You're not leaving. You're not leaving me. Promise me you won't leave me. Knowing wholeheartedly he had already seen the email from the day before because he has some sort of capability on seeing all of my emails. I don't know how that happens, but he saw it.
Were there discussions prior to you leaving about the schooling of the kids and
Yes.
how that was to be
Yes,
handled?
and if I can touch on that, I have evidence, Judge, that it's broke down, complete knowledge of Miss Alex knew. Gavin had to audition for LVA. This LVA is an art school. Our son is an artist, not an athlete. Alex insisted that Gavin attend Bishop Gorman last year, which we couldn't afford anyway, but we struggled to pay the payment. And if you look at the payment history, we couldn't even pay it until the spring of this year, right, so that we could even get Gavin to take his finals. We struggled to pay it so he could take his finals this year.
Right, so the answer to the court's question was there was
complete there was complete agreement, and all of these documents show that he had to audition in May. He enrolled, he had to apply, he had to audition. He auditioned on Mother's Day weekend.
And Dad was part of this process?
Yes, he was. We were living together. How could he not know? And let me intersect for just a moment, Your Honor. If you look at one of his exhibits, if you look at one of his exhibits at the May snapshots that he has for Mother's Day weekend, Mother's Day weekend was the weekend that Gavin auditioned. My oldest son was here from Indiana, who is not even on those photos. He was in complete awareness that Gavin was auditioning. Gavin stayed up pulled an all-nighter that night, even preparing his portfolio. He made it in. There were only 2 openings. He made it in. Even on here, we met in June the 2nd with the counselor talking about his studies and taking summer classes, and he even enrolled in Clark County taking 3 summer school classes this year, Your Honor. He didn't take summer school classes at Bishop
We're getting a little bit
Gorman.
beyond where we need to go. Let me ask this question then. If there was not an order of protection extended in this case or kept in place, what would your fear be going forward? In other words, you're asking the court to keep the order of protection in place or extend it, even if that was for September's hearing. But what do you fear happening?
He would go back to stalking me. And that's
What's left as far as hacking and stalking?
Well, I still don't have, and what he's saying is our joint Facebook. That's not the case. It's my email, my Facebook, my face. Everyone knows it's my friends.
I know. I guess the court's point is we issued an order of protection based on your allegations of stalking,
right,
of hacking, of in the altercation with the son. Now that it appears as if the damage is done, what more can happen going forward if we didn't have an order of protection is my question. What are we fearful of? Because I have to make the determination whether we need this any longer or not.
I am afraid that even with the protective order, he's already violated it, and I have documentation of that. If you take that away from us, he will be at my doorstep. I want to be able to go out and walk the dogs in my neighborhood. I had to move in a guard-gated community because the gated community didn't keep him away. Because he's on surveillance there, the security guard and even the maintenance man saw him stalking me, sitting in his truck waiting for me to get there. And then that's why I moved into a guard-gated community, trying to not have him know where I was at. But he found out where I was at because NV Energy sent my an email confirmation to my old email address, which I asked them not to. That's how he got my address.
But that's a big step from in March agreeing to be roommates and co-parenting from the same location to going to essentially creating a compound for yourself and the kids.
Because of, again, it's okay as long as I play by his rules, put on my happy face, go to, our son's trips and put on my happy face so he can take photos of us and put it all over social media so that he can create this facade of a happy family.
Right, so
but it's not true, Your Honor. If the whole thing is our children are afraid of him, and I'm afraid of him as far as...
Well, that's my next question. What do we do in the interim if we agree to keep the order of protection in place? What's your position with respect to Dad's contact with his children that he was exercising as recently as, except for this little vacation to Seattle, everybody was in the same home and he was exercising time with his children?
It was strained exercise. I mean, they were begging me to leave.
He's not the coach of Gage's football team?
He, not on the last fall team or spring team. He was not the coach. He didn't call plays. He was filming and, watering, but he was not an active coach. And now, and this is the whole thing, Gage he loves football, but he doesn't want to play this year because every season his dad moves from team to team to team, and he can't build some sort of camaraderie with his teammates. And also, he doesn't want to play on a team where his dad's the coach, is what he's told me. I don't mind. I love watching him play. I don't mind him playing if he wants to play, but I don't feel like at this point he's so stressed out. I don't want him to feel like he has to play this fall.
Right, so is it your position that the children should have no contact with their father going forward?
Gavin does not want to have any contact at all, and Gage doesn't want to have any contact where he's not supervised, is what he said. And that means taking his brother, and I don't feel like it would be wise and beneficial for the children. I mean, listen, I want to learn to co-parent with him separately. I don't mind. And back to Gage's school, listen, Gage can't take his placement test at his school.
Right, again, we're getting...
I know, but
this is
Your Honor...
This is going to be for Judge Moss. This is way too much for us.
I understand.
brief
But he's
hearing
making it
kind of
sound
work.
like I'm impossible, but the child couldn't take his placement test because the bills weren't paid. And so I've been forced to make these decisions because there's no communication. I have voice messages that I submitted too that I tried to talk to him. Alex, we need to get a divorce. We need to learn to co-parent. It's over. He's like, stop saying the D word, stop saying the D word over and over and over. I'm afraid he's a flight risk for Gage, and so is Gage. That's why.
All right, well, that's
The
not,
other thing.
that's not going to happen, or he
Okay.
would never have a relationship with his
Okay.
children again. Mr.
Okay.
Stoff, I'm going to let you finish up, and then Mr. Carmen will respond, and then we're going to have to.
Well, I mean, we've got to do something. I mean, shutting off completely is obviously never a good thing. I don't know. The disturbing thing, I think it's been almost, a month since Dad saw the kid. So if you do the Donald's House orientation, we're already on a Thursday. You got to do the Wednesday, Thursday thing for custodial, non-custodial parent. That puts your time basically into a week and a half or so from now. I don't know if there's a public place. I mean, I hate to say at Chuck E. Cheese, but I mean, what other place really is there for Dad to at least have a pizza with kids where it's, I don't know if you want to have mom or some friend be present, distant, or what. She's saying they can come up with a third party, and I don't know if there's going to be argument on that. Maybe Plan A is, a party, a third party that they can agree on. Plan B, I think it should be a Chuck E. Cheese or something. I know that sounds silly. We got kids that are 9 and 15, but what do you do? What do you do? I mean, we think that at a public place like a Chuck E. Cheese or going to a park or something, that people ought to be on their best behavior. No kid should be thinking about defending or resorting to violence or things like that. But we have kids that are afraid of Dad, and the healing needs to begin. I think counsel and I could certainly agree with that, that we have to have some healing begin. So the only way around that or to get to that point is have that first contact. So now, I'm not sure Dad's schedule. I don't know if he's Monday through Friday, whatever the case is, but we're at Thursday. So I think it's most appropriate to have the first visit be happening like 48 hours, somehow, on Saturday, something like that, for a couple hours. It just has to happen. And then at some point, there's going to be a Judge Moss situation to have to deal with everything. Where do we go from here without prejudice? We have to have something. And I don't know if Your Honor wants to do an FMC child interview, which obviously would take place after the first visit or two. Maybe some of the tempers have calmed down or whatever the case might be. But, I mean, the kids want to be heard, but there's no way to pay for a private third party to do this type of thing, whether it's a Claudia or Ponzo or whoever. These are all just issues we have to deal with. So now, his counsel might be saying that, okay, if we have a child interview, that's going to further empower the children, that what they're going to say, that they're aligned with mom, et cetera, et cetera. They may or may not say that. Who knows what they'll say. But obviously, if we had it like today, tomorrow, it wouldn't be appropriate because they haven't seen Dad in a while. But if you have it at a Chuck E. Cheese or with a third party, the healing can begin. So she's asking for this order of protection to be not only extended, but to certainly remain in place, or if the court's inclined just to continue it and have a status check in a month or whatever the case might be. So there's a lot of issues that have to get sorted out and on this case. The September 7th hearing, that won't work for me. I'm at a trial, so I can't even do that hearing, so we need to move that date no matter what, however you cut the cookie on this one. But so if it can be pushed out a couple weeks, that'll give perhaps additional documents to be exchanged back and forth, if there's things that were sent and not received, whatever the case is. But we want to have some history, so then when you come back in this department in about 30 days, you'll have at least a couple of visits under our belt, and then we'll know where we're at this point in time. Certainly either party can file a motion if they're inclined to with Judge Moss, then the court would probably be inclined under EDCR 522K just to kick it there, and then Judge Moss can deal with it. But if we're out with a return hearing in this department in approximately 30 days, that'll give this court more direction. So if the TPO is just continued until 30 days, that might be the easier way to tackle it. The situation might be different in 30 days.
All right,
so we need a Band-Aid to go from now to the next 30
Let me
days.
hear from Mr. Carmen, and then also with respect to contact with the children and what the proposal would be.
I just got to say this, Judge. This idea that him desperately trying to find out where his children are and see his children leading up to the TPO is somehow stalking is an absurdity. She takes the kids, doesn't tell him where she's going, And yes, he wants to see his kids. She's using the children as a weapon in this case, Judge. And those text messages that you do have copies of, I understand you haven't heard the voice recordings yet, the text messages show that she's not afraid of him. People who are afraid of other people don't intentionally antagonize them, don't threaten them, don't threaten to sell their childhood collectibles when they're not cooperating with an exchange of shoes. This process has been so abused by this applicant, Judge. She's used it to manipulate the children's school enrollment. Did he know the child was auditioning for LVA? Yes. Did they have discussions about him potentially attending LVA? Yes. But the reality is they never agreed to it. They didn't agree on any of these. It's just like the football. Gage suddenly doesn't want to play football. Can you make a guess why the child doesn't want to play football? Because he's been around Mom for the last 20 days, who's been complaining about Dad, just like she was complaining about Dad in those
I get
days.
it. This is a completely dysfunctional situation that we're not going to be able to fix, and it's causing some potentially irreparable harm on the children. They're being torn. We know children will placate each parent to try to make their environment more comfortable, and all of that is going on, Mr. Carmen. I don't doubt that.
The one thing I'm disappointed with Mr. Stoffel about is our initial telephone conversation in this case said Dad needs to have some visitation. Let's have Nick Ponzo or Jamal Ali, two well-respected court counselors, just be there for the first couple of meetings to try to de-escalate any problems that might arise. Their answer was no. So it's ironic to me that they come here and they say, oh, we need to start visitation, we need to do this, when we made a proposal and they said no. Their position up until a few moments ago was zero contact, Judge, and we can't afford to do this the right way, so we're not going to do it at all.
Well, and that's not how it's going to go. What I need to know is what would be appropriate temporarily for. If we don't look, we already issued the order of protection predicated on an ex parte submission. We all understand that that isn't going to be determinative or dispositive of the issues going forward.
My suggestion is, and I know you're looking for an answer, and my answer is
I'm not familiar enough with what's in these children's best
we
interest.
suggest that we get Nick Ponzo on board right away. He can supervise a couple of visits between Dad and both children this week, and he can decide whether we can go forward with unsupervised visitations or whether additional supervision is necessary.
I'm prepared to remove Gage from the order of protection. I didn't hear any testimony to suggest that Dad presents a risk or a threat to the younger child. Whether he's coaching one particular football team or moving from one team to the other, Dad's still actively involved. He spends time with his child, coaching the football team. Whether the child wants to stay on one team or jump from one team to the other, that's not what this is about. So I'm prepared, unsupervised, with Gage already. Gavin, I have an issue with because this is not the first altercation. Again, I'm not using what happened in January.
That's why we want Nick Ponzo there for the first couple of visits, just to smooth this over.
Well, and that's something the two parties, through their counsel, would have to stipulate to. I'm going to put some temporary in place, so I'm prepared to entertain what you suggest would be ideal for maybe Gavin, but Gage can go spend time with Dad now. They go to football together, the two of them, without any supervision as recently as a few months leading up to the order.
But the point is, if you don't order that, the status quo of football enrollment's supposed to remain in effect, that Gavin should be seeing Dad, it's not going to happen. I understand we may have to go in front of Judge Moss, so we may need to do an emergency motion. But Mom has made it really clear that it will not happen, Judge, unless she's ordered to do so. That's the concern that I have.
Okay, so tell me what would be appropriate for Dad's contact with Gage.
There's no reason Dad shouldn't have half the time with Gage right now. I think that the first two meetings should be done with the older brother, with Nick Ponzo, just to make it easy, the transition for the child, so that the child can be there with a third-party therapist to help guide him through this process.
Stoffel?
No money for it. That's our objection. We don't have $1,000, $2,000.
My client will pay it, Judge. We just need to get this moving and do it
Done,
the right way.
right?
First I heard of this. If he's got money,
That is so not true,
Well,
Judge.
he might have to beg or borrow or steal it.
Right. Whatever the case
He
is,
probably
then
doesn't
make
have
it
it, but
happen. Sure.
it will find it.
Sure.
And the irony of this is she's the one who took $69,000 and can't account for it. It amazes me that she can stand before you and argue that he somehow controlled her financially, that he has somehow that there's no money and we can't do all these things. She couldn't get an apartment. She's the one who had their money, Judge, and to this day refuses to account for it. I understand it's not an issue before you, but it becomes an issue when she uses the money as an excuse as to why things can't get done in this case. We do ask, too, Judge, again, if this TPO is going to be extended at all in any way, shape, or form, we are asking you to restrict her communications. She is publicly libeling him. She is attacking him via text message. You can't have a TPO that only goes one way. If it's going to be extended, it needs to be a two-way TPO that's going to preclude her communications with third parties. Since the TPO has been issued, she acknowledges that she's communicating. She's, again, prior to the TPO, she's texting all their friends, demanding that he speak to her, demanding that he call. Subsequent to the TPO, her friends are doing the communication and disparaging and attacking him about shoes, about silly things that really shouldn't be before this court at all. So if a TPO is going to be extended at all, it should be mutual as far as contact between the two parties. We've suggested again that a mutual behavior order is the appropriate remedy in this case and that it doesn't warrant a TPO. But without Mr. Stoffel's cooperation or without the D court getting involved, I'm not sure your comfort level on issuing such a behavioral order, Judge. And I know it's we're in a tough setting. My client really just wants things to go back to as much normal as possible as far as the kids. I don't think we can salvage the Bishop Gorman situation, but we do want to salvage Gage's situation and want him at his school and want him in football. And Your Honor, the other big issue between the parties, and I don't know that you want to address it, is in regard to the family pets. I know outside of this courtroom, she was complaining because he still has possession of the family cat. She took the family dogs. I don't think this should be part of a TPO at all. But these things are causing problems between the parties.
It comes up more often than you would imagine, even in TPO courts.
So sorry for you.
So she has what are you proposing should be the situation? With
the dogs should go with the kids. When Gage is at Dad's house, the dogs can go with Gage. If she wants a cat, I don't even think my client has a problem giving her the cat back. Mr. Stoffel just needs to communicate with me so we can get whatever property she wants in the house. She wants a cat, we can work that out. But the dogs are really important to both parties, and there's no reason they can't go to both houses with the children.
All right, last word, Mr. Stoffel.
Well, just the first thing, I guess, with this whole Ponzo thing, obviously, we welcome that idea. I guess the disconnect, I guess, was the money thing. Is if they think that there's money laying around and she's telling me there's not, then there's not. If he can borrow the money, beg the money, whatever the case, that's probably the best course of action to have. So then that way you can have a more immediate response. Now, as soon as they can get on the horn with Nick Ponzo to make this happen, notify my office when and where she will be there at whatever time. If you want to have a couple visits to happen, and that's where we're at. She's indicated to me regarding Bishop Gorman needs that iPad back because they're holding on to, I think, the transcripts are causing some sort of problems with the Las Vegas Academy of the Arts. So there's just some property, and there was correspondence to that effect that was sent out to the parties saying, hey, we need certain things or we're not going to do certain things. So that's an issue. Some of the personal property stuff, we pled in the complaint that it hasn't been exchanged, it hasn't been done. She wants some of that stuff that's back. It's already in the complaint. If they can work it off, great, but they can't. There's a TPO in play. So we don't have to make orders today regarding extending the TPO. We can make orders just continuing it until we come back, because this will probably be a different situation, or we'll have more facts presented to this court in approximately 30 days. So what I'm asking is to vacate that September 7th hearing and just push us out about 30 days or so from today, and that'll allow some contact. If the order wants to say all visitation has to go through Ponzo absent mutual agreement, or if Ponzo recommends, hey, I don't need to be here, have Dad see the kids at a Chuck E. Cheese, it's a setting, everyone will be on their best behavior. It's just, even though they might not be playing games, there's a lot of different games that are there, or go to a GameWorks or something like that. There are ways that you can have some natural human bonding. There's ways to do that. You can talk about current events, how is Seattle, how is this, how is that. Just things to have that can build this healthy relationship. And then if we come back here, the middle to the end of September, that's probably the best course of action. We'll know more information, and then you can just carry over her request to extend this TPO out to that hearing. Just continue it, just band-aid it between now and then, And really, that's where we're at, Your Honor. So there's problems in Paradise. We know that they're incompatible in marriage. We understand that. But the protection of the kids. And again, as far as Gage, one of the things you said, Your Honor, is there's no indication that Gage was ever in any threat of harm or anything. Her application indicated that scuffle with Dad and Gavin, that Gage was scratched and had just some sort of light scratchings, light injuries. But that we might be able to get past that if we go through like a Nick Ponzo, and we can really dissect this like a bad onion, get rid of those top few layers and see what's what. And that's really where we're at, Your Honor. So that's what we would ask you to do, is to continue this TPO for about 30 days. If you want to order the Nick Ponzo thing, she'll get full cooperation on that. If she doesn't cooperate, that's custody suicide, Your Honor. So she has to fully cooperate with that process to get this voice in there. And it eventually will be a one-on-one or maybe two-on-one with Nick Ponzo or whoever, and the boys to really go through what's what here in this case. This is also a situation, Your Honor, that you might also want to see that report as well. So I don't know if I don't think counsel mentioned, but if there is communication, there's a report, I think this court should at least welcome the report regarding the level of security that the boys would have with Dad perhaps alone or outside of the current setting. So I think the court needs to hear from the voice. One of the things Goldie wanted me to bring up is it's possible to consider appointing a guardian ad litem for these boys to give them a voice if necessary. That might be premature if we're going through Nick Ponzo anyway, but if we ask that this court wants to get a report perhaps a couple days prior to the return hearing in a month or so, that might be helpful to give this court additional insight, because this TPO is unique. It's on behalf of mom and also both children. So knowing what we have with both children involved in this process, they should at least be heard. And if the best we can do is with Nick Ponzo reporting back to this court in a welcome report saying, here's what's going on, here's how I see it, with or without recommendations, the court can make that call. But just seeing some outside thing, what is the comfort level of these boys? That's what needs to be known.
All right, this is way too much for this court to try to handle on an order shortening time without all the documents having been exchanged, without full briefing, and we're asking a little too much of this court to do on such short notice. As I already indicated, this court issued an order of protection based on the testimony of the applicant, and it was done in an ex parte capacity. Court's not about to extend the order of protection based solely on that. However, the court's not prepared to dissolve the order of protection just yet either. This is too volatile a situation. The allegations are too conflicting, and we're polarized. It's extremely dysfunctional. We have children who are engaging in physical altercations with their father because of disagreements and fights, and you know, this was all a product of, I think, two parties with two different objectives, and that never works. It can't work to just be roommates when the other party isn't in a position or fully on board with just being roommates. And I think after time passes, when you're involved in that type of scenario where you're in one place and he's in another, and there are false hopes maybe that were built up as a result of the construction of this arrangement, that it ultimately, you know, leads to a blow up, for lack of a better term. So the court's keeping the order of protection in place. We'll look for another date other than September 7th. Mr. Carmen should be considered in that decision as to what date will come back, because
just
we've
so
had
clear,
September 7th.
my understanding, you're doing that without findings. This is just, we're continuing it to that date without any findings being entered?
Yeah, I mean, there's no findings at this juncture on the request to extend, because that wasn't supposed to be heard until September 7th.
I just don't want this to have precedence in the D case.
I've got
when we get
without
before
prejudice
Judge
written
Moss.
on my interim order.
Beautiful.
This is not going to play a factor in Judge Moss's determination as to what should be put in place in the children's best interest. Dad will be able to fully assert his rights to primary custody if that's what he's seeking. Mom, you'll continue to pursue sole legal and sole physical if that's what you feel, and if the court buys it, then that's what the court will do. If they determine that's what's in the children's best interest. Nothing today is to be interpreted as an indication as to what the custodial arrangement should be. I'm removing Gage from the order of protection, so it'll be Goldie, and on behalf of Gavin, the order with regards to custody is and again, I put without prejudice, but temporarily the children are with mom primarily, without prejudice. It's just a product of where we find ourselves because of the process. If Ponzo is going to be retained and he can facilitate the first visits and exchanges, court's not, of course, not going to have a problem with that, but that's still something that has to get arranged by counsel. We don't know his availability, and I'm worried about the delay. Dad's going to be deprived, it should not be deprived contact with his children as we try to retain an expert who might not be available for 30 days before he gets paid, but I trust that, that Mr. Carmen, Mr. Stoffel will make arrangements to contact him and get this in place as soon as possible. What I've entered in my interim order is that starting next Friday, so I'm going to give you today and tomorrow and next week to try to get Ponzo to do something that will help smooth this transition. But if that hasn't happened, Dad's going to have visitation with Gage next weekend from Friday after school. Is school starting by next Friday?
29th.
Hmm. All right, where would we do a Friday exchange? It's going to be a week from tomorrow. I hope that Ponzo helps and you guys put something in place and we won't have an issue so that he can help broker this. But is there a place where Dad can get Gage next Friday if we haven't made any progress to do something else that all the parties and Ponzo agree on?
I would just say, if nothing else, mutual agreement between council as Plan B right in front of family court, probably the easiest way to do it, as a distant Plan B. They should be able to work something out.
Where do the parties live? Can't we just pick a McDonald's or something
it seems
neutral?
like we
in
could
the
find a
neighborhood?
more convenient location than...
Do you have a suggestion?
I mean, you know where he's at.
See a football
No,
game.
what about Gage?
The court can address that.
Okay.
Are you still taking Gage to football
He
practice?
doesn't want to go. He's refusing to bench, and he's
Why?
been refusing.
He loves football, I heard.
I'm just telling you, and that's why I asked for him to be interviewed.
Is he in the mid-season of a session?
It's
It
just
started
started.
this week, Judge.
It just started
And he didn't go yesterday,
Tuesday.
And he's
It was
not going
Tuesday,
tonight?
Wednesday, and Thursday. He hasn't wanted to go, but I will ask him again.
Your Honor, and I hate to intervene, but this is not something that a child should be asked. A
I-
9-year-old
He's
should not be
not
given
wanting to go.
discretion whether to
I'm
attend their
perplexed as to
extracurricular activity.
why he's found himself not wanting to go and not liking football. But
He
again, there's
loves-
more going on than we can decipher.
Exactly.
I agree. She'll do her best to strongly tell him that the court's expectation is if he's done football before, why stop? And so kind of status quo in some things like this should be maintained.
Missing 3 practices or whatever's going on is making him fall further behind. Are you coaching that team?
Yes, sir.
You've been there the last 2 days.
I've been there for the past month. We've already started practices. His registration, everything's paid for. He's going to be back with all of his friends he's played football with for 5 years. All of his friends are waiting for him, all the coaches. I coach at the Pee Wee level. He won't even be, I won't be on his team per se. He'll be on the other side of the field, but at least he can be there with his teammates and his friends he's played with for forever. I respectfully request this. Yes, sir. I do coach for them.
And I hope Your Honor understood the disconnect in the testimony, whether he's getting water for the team and assisting the coach or whether he's the actual coach. I think you understood he's involved with the activities.
Wednesday, Thursday, Saturday morning.
Could we do the exchanges at football on Thursday, Judge?
I'm just going to... One second. So again, without prejudice, Ponzo's going to facilitate the first visits and exchanges if he can get retained. The adverse party will pay for retaining Ponzo. We're going to restart football next week, starting Tuesday. You're to drop him off at his football. Dad will be there. He's already part of the process, and then you can come back and pick Gage up after football.
Okay.
That'll be if we don't have Ponzo on board before then, that'll be a good opportunity for Dad and Gage to have a little time doing something that Gage loves, and hopefully that will lead to the transition. He's to go each night he has football, and Dad can be there with Gage. You can even telephonically communicate with Gage because we've removed Gage from the order of protection. We're going to have starting next Friday weekend visitation with Gage from Friday at a mutual public location. I'm going to let council try to get that arranged. I'm out of time. I got a trial that was supposed to start at 9. So I trust Mr. Carmen and Mr. Stoffel to make sure that that happens on Friday afternoon. After that, it'll be at school pick up and drop off. We'll drop back off on Monday morning. That's the first day of school. So, and as far as Gavin, the order of protection is still on behalf of Gavin, but I've made a notation that it's to be at his teenage discretion until Ponzo gets involved. So probably no contact with Gavin in light of what I'm hearing, but if once Ponzo's retained and he's part of that process, Gavin's teenage discretion, but Ponzo and what you agreed to will trump my order of teenage discretion.
And if we can get Ponzo on board ASAP and get some visits before next Friday, I assume you're okay with. I mean, that's what you're contemplating here, I presume.
Right.
Thank you, Judge. Thank you for your time today, Judge.
Do you want a report from Ponzo or not? Because
I don't need a report. We're going to have a date where we're going to come back here. I'm trusting that this is going to find its way into family court because I know probably neither party is satisfied with the temporary orders coming out of this court, but we're still going to set a return date because ordinary course in Department I may be longer than the parties are hoping for. Anything around September 7th, we're going to let Mr. Carmen have first choice of the date.
We could do September 15th at 9:30.
That's good with me.
That's even less than 30 days.
that works for me. I mean, we'll know more then.
Are there any other matters stacked on that day?
There is. Do you want me to find a day that has less?
Do you have an opening at, well, how many are on at 10?
There's 5 on at 10.
How many 11?
None at 11.
One of the 10. What day of the week is that?
9:30. That's on a Thursday.
One of those 10 o'clocks might have been an evidence.
Let me check.
Let's keep it with what we got since both council are good.
One is
September 15th, 9:30.
As far as some of the personal effects, some of Gage's stuff, some of Mom's stuff, I mean, she wants the stuff as soon as possible to get it.
Council, I've suggested that we just come up with a time and a date to exchange it. I don't know what
Are
more.
there any items that you feel would be controversial or that he may refuse? What items are, I know about the shoes.
We're talking about Gage's stuff or what?
All of Gage's books and backpack. I haven't been able to do any of his tutoring all summer, or this amount of time he's had those belongings. Anything
I can't
with
broker
Gage.
books and let Mr.
And Gage's
Stoffel and
toys.
Mr. Carmen handle this. If there are any items in dispute,
Is Gage going to attend ICA? Can we get an answer from?
It has to be. He couldn't take his evaluation, Your Honor, because the tuition wasn't paid for June. I mean, for the following year, and he has to be. So he wasn't even registered for there when I checked.
we all know the protocol is the child remains in the school that he was attending before unless there's...
That's the
But there's-
protocol, but
But there's
hasn't
no,
been
but there's
allowed
no
by law.
money, Your Honor. I can't pay it, so they wouldn't even do the assessment. And they said that they contacted Mr. or Alex about
Ponzo
it.
help with these types of issues as well?
No, but council though can get involved in this, and
I hope so.
Your Honor, I mean, I at least would ask that the order be that the status quo is going to be maintained unless parties can agree otherwise.
If the child hadn't paid for the school, I don't want him locked out of school.
He's enrolled in a public school. I enrolled him yesterday.
How does
just
that happen
because-
without that?
Mr.
Because-
Carmen brings up a good point. How does that happen
Because
without that?
because they won't register him at ICA.
That's not answering the question how this is all happening without Dad being involved. Mr. Stoffel, Mr. Carmen, it may warrant another emergency motion. I'm sorry to put the parties through that. I don't know what to do because with respect to with respect to money, with respect, I can't make this decision.
I just find it curious that she's here. She won't even tell us the name of the school. This is the most bizarre situation I've ever seen.
It's
Judge.
just the school down the street from my.
This was just the topic of a bench bar conversation on
I'll
last
tell you
Tuesday
the
about
name of the
judges
school.
having to make a decision about schools
Yeah,
Right.
yeah.
and not wanting to do that because we're the last ones to know what would be the appropriate.
Yeah, my client will contact ICA today to find out if there's any truth to if there's a registration hold. It'll be his obligation to clear that up. If it's not cleared up, the child, I guess, will be enrolled in a public school, but it should be one that both parties are in zone for.
And I'm okay with that too, Your
I mean,
Honor.
I mean, I don't know.
I'm
you guys,
okay.
I can't.
All right.
I'm just not in a
I
position.
know, Judge. I'm sorry for even asking. I just, I
I'm okay with that. I'm okay with
okay, so my client will do everything in his power to clear up whatever problems there are with ICA.
Schools are not listed as protected locations on the order,
They were
correct?
listed in the application.
They were, right. But if we're going to move Gage from it, then that would
It won't.
eliminate
It
that.
won't.
It doesn't eliminate the school because mom and older brother can still go to the school, so sometimes the other child's school is
Older
still...
brother's at a different school. So the younger child's school, it was
But
listed
what I'm
as-
asking is, Mr. Carmen, you just said your client's going to go check out with the school what's going on. Is that school
It is. It's
on the
listed-
order of
it's,
protection?
I believe the International Christian Academy is listed on the order of protection. That's why I'm asking about
It
it.
was, so it can be expressly lifted for
All
this
right,
purpose.
I'm removing it.
That's fair.
International Christian...
Academy. I hope I'm that name.
All right, so we've removed Gage, we've removed the International Christian Academy. We got to recycle those, Diana. Thanks. All right, thank you for your patience and your time. I appreciate
Thank you.
your cooperation. We understand the spirit of the order. I may not have captured everything in my interim order that we discussed, but I trust counsel to make sure this goes the way it's designed to go. If you need us for any reason, it's simpler than doing a motion for, you can just file an application at the TPO office to put it back on calendar. For instance, you're not getting one of the property items and there's a dispute over it. I'd rather not, but you can...
I promise you there will not be a dispute over that, Judge.
I appreciate it, but if you need us, come back. Don't take matters into your own hands. Use your attorneys if you can.
Yeah, and I also, and this is one thing, I hope it goes without saying, that the spirit of the TPO is that disparaging comments about Dad need to stop. I mean, I assume...
Look, and I meant to. Oh, there were a couple more comments. I won't put it.
I'm sorry,
We're
just-
still on the record. I didn't put in my interim order. First of all, Mr. Carmen, you had asked for some type of reciprocal understand. These are very much unilateral orders. There is no. First of all, we don't have jurisdiction to issue behavioral orders. We also don't do mutual restraining orders. He hasn't applied for one. There has to be an application before the court would ever entertain an order of protection coming from him against her. So we can't agree. I do have a note about the dogs should travel with the kid. If it's Gage, sorry, I shouldn't say kid. That's not nice. The dog is Gage's dog, and Gage is entrusted with taking care of this dog, then the dog should travel with Gage. The cat, look, everybody understands, kind of like the school, which animal goes with which party. It's silly that we have to make that determination. We, as a family, know who the animal is attached most to. Let's not traumatize the animals, the children, the parties, and everybody involved in this process. Another thing, don't involve your friends and your family in your extracurricular communications. This isn't reality TV where the Kardashians let the other friends in on what all is going on. So that does need to stop. The disparaging remarks, despite the parties' imperfections, despite the parties taking some type of, and both of you, inappropriate direction and inappropriate conduct, the children, in the children's eyes, and they're old enough already, this is usually for younger children, still think Dad's pretty cool. He might have some, and they need to think that. They need to think that going forward. We do not want this to destroy the relationship between Dad and the children for the rest of their lives. Same with Mom. Mom has made some decisions that you probably don't appreciate, but in the children's eyes, she still needs to be Superwoman. Okay, despite all the problems, and it's hard to say, and it's even harder to do. But that's the idea going forward. So the disparaging comments in the presence of the disparaging comments overall need to stop, but in the presence of the children especially. So I don't want to hear about that, or that could be back before us on a contempt proceeding. One more thing. We had the alleged violations. We'll discuss that when we come back. The court's not issuing an order to show cause today. We will put that on our calendar for September 15th. We're vacating the 7th. We're on the 15th. We're also vacating. There's a motion in Department D to dissolve this order of protection. That's going to be removed from Department D's calendar as well.
Department I.
You want to leave it there?
Aye.
Yeah, it was a
The
D
case.
case.
D case, Department I, sorry.
Just as far as the TPO allegations go, is discovery open? Can I mean, if we're going to walk back into court in September and discuss our OSC allegations, can we at least engage in some discovery, Judge?
I can't preclude it.
Okay.
But, I mean, with cost being a factor, it seems like we're spending a whole lot of money on legal counsel to
I just
further...
don't want my clients' rights to be... It's one of these things with under the TPO rules, it's really unclear as to whether discovery...
I'll give you a little insight on what I'm thinking. My hope is by the time we get back on the 15th, there won't be a need for an order of protection because this will have been sorted out with Ponzo, with counsel now being involved, with the new supplemental exhibits, 70 pages or 700 emails or whatever it is. By the time we get back on the 15th, we will have figured out a game plan going forward where we won't need the extended order of protection. That's the court's hope, but you're still going to get to present your case for why we need an extended order.
Thank you.
What time on the 15th?
9:30.
9:30.
It's on the interim. Did I print out the new interim order after I added the Christian Academy? Okay, and we've got everybody's got a copy?
Yeah, we don't have a copy yet. We were told to wait outside, I think, for it.
I've got one for everybody. Here, they're ready, Rich. Okay, so thanks again for your patience. We'll see you back in a month. I hope things take a turn for the better.
Judge, thank you for taking so much time.
Thank you, Your Honor. Appreciate you.
Yeah, we'll do. Yeah.